Beautiful, beautiful people. Hey there. And as always, welcome back. Law and legal things are invincible strings that are tied to reality. When you look at any land or a given body of structure, there are laws governing that thing, how it can be used, why it exists, and how it can be used. It's the operation of that law, which is called legal things. To think that someone could think of something, write it on a piece of paper, and have it affect the totality of lifestyle of people, whereby society at large amend themselves to it, one way or another. With the whole C-19 thing, people are amending themselves to things that are just based on executive order that only applies to executive department and agency. Those aren't even laws. Imagine the things that's passed by a legislature that affects people every day. And since people are born into habits and pattern of things, and since humans are creatures of mimicry, people just carry along with it without thinking twice. Whether that law or the color of the appearance of law benefits them or not. Because laws, man-made laws, are supposed to benefit man. And the only way man-made laws can ever benefit man is if they are harmonious with nature's law, divine principles. To think that someone can write something down on a piece of paper and it will affect people's lives daily, whether they realize it or not, that is powerful. That suffix ment within the term government, ment just means mind. It's a Latin term for mind. Govern is to put things in order. So if one thinks that which is spiritual or substantive, or the cause of reality itself in the physical realm, is far removed from legalese and lawful things, and they think arbitrarily doing things without being spiritually inclined is going to get them where they want, they ought to think twice. Because someone is taking that which is in their minds, they'll put it on a piece of paper. If one is not spiritually inclined, this thing called law or legal aspect is tied directly to freedom, as an invincible string that attached to. Have you ever seen a cobweb during the daylight, whereby if you don't move at a certain angle or perceive it at a certain angle, you will not see that cobweb until you come in physical contact with it. Only then would you go into a state of distress, wondering, what is this odd feeling on my face or my hands? That's exactly how law and legal things are. You have to see it from the totality of the angle. You have to see it from the proper angle, and you have to see it from the totality. You have to see where it's coming from, where it's going, and the nature of why it exists, so that you can amend it, rather than you amending yourself to it. It being the mind of someone else that's been placed in order by way of some form of government to rule over you. In other words, competency on a level that goes beyond you merely reading pen and paper is required. Because most people will never get things of this nature beyond being emotionally stimulated, which is fine. That's good. But if that's the end and the beginning of what you say is lawful or legal, or what you say is not lawful or not legal, and you don't realize that you need something more substantive beyond your impulse, most people have not, and currently aren't, and will not survive or reach that which they perceive as freedom. You need to see the totality, and you must comprehend that law itself is spiritual in nature. On the note of Fourth Amendment, right to be secured in one's person's papers in effect, but more so specific to traffic stops. Many people travel around every day, one point to the other. And there's this huge speculation that goes on regarding traffic stop where people say they can't do this, they can't do that. We're going to clarify a lot of things. But before clarifying a lot of things, here's a premise for you to know as an underlying factor. Those roads that people travel on, to and fro, some of them are based on public trust doctrine, whereby some municipalities and their representatives and contractors build it for the purpose of preserving it for public use. But 8 out of 10 roads that exist at North America, any given road that you lay your eyes on at any given moment that people engage in every day, the physical structure, the interest of it is very much private. In other words, the people who build it dictate certain criteria based on commerce and its use. Hence, all those commercial regulation of motor vehicles. The foundation of the issue was not you looking at motor vehicle codes in the USC and saying, this is it, this is it. All you're going to see is definition of what a driver on a motor vehicle is until you're blue in the face. How does that functionally assist you? It will not. The reason why those motor vehicle codes exist is because there is something more substantive to why they exist, which is the use of a road to which those mechanical tools travel upon. Start from there and look at international law when it comes to the right of use of road. We go over it on Patreon. It's very simple. And some people, when they say they figure it out, they still steer the wrong path. And their belligerence and their little anger inside of them prevents them from really actually functioning with solution that they think they found. And part of the reason why people remain angry, despite the truth being in their face, no matter how small the percentage of people who might have found that quote solution or quote remedy, there's still an element of anger. I'm here to remove that anger and wash it off with some competence. Because when you know you're not afraid, anger is just a derivative of excitement of fear. That's all that anger is. And the only reason why anger exists as a derivative in a form of excitement, which is fear, the only reason why it exists is because of some form of lack of competence. It is human nature to be afraid of that which is unknown for the purpose of survival. It's just that simple. So most people go out here living in survival mode day in and day out because something is not quite clear in their minds. Most people would take the proper steps to do an injunction, take the proper steps to not put a vehicle in their personal names, take the proper steps to obtain certain things and do certain things a certain way, yet somehow that tortfeasor on the other end still kicks your ass. Something is amiss in your mind. And this is the missing link that a lot of people don't comprehend when it comes to traffic stops and Fourth Amendment. First, we're going to go over what most people like to hear. Then we will graduate into what most people don't like to hear. What you don't like to hear is that missing link to what you like to hear, which gives you the total perspective that will truly make you free, so that you can govern your affairs by governing your mind properly, rather than having someone's mind govern your daily affairs, to which you have to constantly amend yourself to. You increase your heart rate, you kill your health mentally, physically, spiritually, because you get angry at someone. That man or woman who stopped you is probably a crackhead who supports his habit by stopping people and getting all those commissions for traffic stops. The moment they stop you, they're not even thinking about you after that. But you're left with anger. You're left with a track record, which in truth is actually defamation, conversion, etc., etc. But most people don't even know that part in the future because they don't even know the basic stuff that's happening to them now or how it's affecting them in the past. So let's deal with the imminent stuff right now that you need to realize before you even start to say you want to hold someone liable or you want to seek some remedy. Your remedy begins with your competence of how to protect yourself. And protecting yourself is not merely you writing some piece of paper and hoping somebody is going to run to and fro being afraid of you. In commerce, no one cares about how you feel. whether you like to accept it or not. Commerce is everywhere. And whether you like to accept this or not, you ought to be doing commerce, but do it properly. When you do it properly, only then can you confidently walk around with that sense of entitlement that no one can tell you shit. Otherwise, you're just a delusional, angry being walking around without competence. And you are creating a track record to screw everyone else over. So let's start with what's soothing to the ear, something you want to hear. Then we'll transition to the fact and truth that aligns with that. Brown versus Texas, 1979, case number 77-6673, appeal from the county court at law. So what is the substance here? It goes on to say the reasonableness of seizures that are less intrusive than a traditional arrest depends on the balance between public interests, in other words, public trust doctrine. All these things interrelate, are not isolated, and the individual's rights, the Fourth Amendment, to personal security, free from arbitrary interference by law officers. In other words, when it comes to this specific case law speaks of traffic detainment and things of that nature, and asking people to identify themselves. So it's telling you, in order for that to be reasonable, it has to consider the public trust doctrine. Is it affecting everyone else? And are they doing their duty to preserve your use of certain things? They're not going to clearly articulate here to tell you, well, what we mean in this specific instance of being arrested in traffic stops is the fact that that road, we have to put into consideration whether it's built for use or it's a private, federally chartered road, where bid bonds and GSA bonds are basically used the same way that it's used to build schools and prisons, but for roads. So the roads effectively becomes a form of prison for people, and we have to regulate the type of tools that travel those roads because they're privately built and privately owned. But we'll just retain appearances though it is for public use, although a very small percentage of public roads, quote, public roads, are for public use. That's what they mean when they say public interest. And they have to put that into consideration and compare it, aka balance, between the substantive rights to personal security. You're free from arbitrary interference by law officers. Law officers being the people who enforce the private interests behind the things that are shown in the public, where people look at ordinances, state legislature that are later statutized, versus other private affairs on a commercial level. That's what's being said here. In other words, what they're saying in summary in Brown versus Texas, this specific portion, because a case law can have several points to it. In this specific instance, when it comes to Fourth Amendment and traffic stops, what this specific section is saying that in order for any type of commercial interest that exists to be enforced, you have to consider your substantive right and our duty of public trust doctrine, if it is applicable. It goes on to say consideration of the constitutionality of such seizure involves a weighing of the gravity of the public concerns served by the seizure. Is it for the purpose of protecting the public? Is the situation dangerous? Is it imminent? Is it immediate? Is it highly escalating? Is any life involved? Or is it just some other private stuff that we're involved enforcing? Consideration of the constitutionality of such seizure involves a weighing of the gravity of the public concern served by the seizure, the degree to which the seizure advances the public interest, public trust doctrine. They're not going to tell you what we mean by public interest is whether the road is for private use or public use, and that most of these roads are privately chartered, privately built, privately owned. They're throwing hints here and there for those who know other foundational things, to which most people who speak about traffic stops and Fourth Amendment rights do not know. Consideration of the constitutionality of such seizure involves a weighing of the gravity of the public concerns served by the seizure, the degree to which the seizure advances the public interest, and the severity of the interference with individual liberty. You have to compare private interests to yours, and Here we are in the middle based on public trust doctrine. Is there public trust doctrine involved? Yes, no? Okay, should we look at your rights even in private capacity? Okay, yes or no? Okay, even if it's a private road, you still retain private rights, right? That is factual. Even if it's on a private road, you still retain your substantive right one way or the other. But the issue is most people engage in activities daily that intermingle with other people's private affairs, others representative of private entities' private affairs, and they don't even realize it. They don't put that into consideration. But what they say when they open their mouth or what they do, these small, subtle small, subtle intricacies play a huge role in the totality of circumstance that you need to see before you put your face into that cobweb. That you need to see so that you know how to navigate. So even on private roads, which most roads are, you still have your substantive right. Therefore, there are certain criteria involved. Pose this to yourself. Do you know these criteria when it comes to private interests and your private right of action or your substantive rights preserved there in Bill of Rights on the federal and respective Declaration of Rights on state level, and the ones preserved by you, reserved by you through the 9th and 10th Amendment or the equivalent on the state level? What are those intricacies whereby things become much more subtle? The obvious stuff is, well, whenever anyone stops you, you have to consider your rights with everything else going on, right? That's the stuff people like to hear. So we've gone over that. But there are many more intricacies. See this thing called Terry versus Ohio? This is the origin of what people call Terry stops, or stop and frisk. On Patreon page, we show how stop and frisk is implemented into each state. They sneak stop and frisk languages into specific types of violations that are not limited to traffic stops. And you must know this based on which state you're at. We're not going to show that on YouTube, but let's go on. The second one we're going to look at is called Delaware versus Prowse, case number 77-1571. Certiorari to the Supreme Court of Delaware. Certiorari is basically an appeal under an appeal, as went over in the past. It goes on to say, an individual operating or traveling in an automobile does not lose all reasonable expectation of privacy simply because the automobile and its use are subject to government regulation. Let's pause here for just a short moment. This is where the concept that people have to have their own license plate on, etc. Sure, you can. Not a problem. You definitely can. But your mere creation of some random license plate that's metallic and that says certain words, private or not for commercial use, this service, that is not according to the language of any law. Sure, there are quotes like that in the UCCs. But how does that relate to your interests as affirmed by the Bill of Rights? Yeah. You're saying you're moving about ingress. That makes sense. But why are you tagging yourself with some stuff that's going to flag you? And most importantly, do you know the foundation as to why you felt the need to even put that in your vehicle in the first place? Because the foundation is that thing that you're traveling on. Who built it? Who maintained it? Who has the right of use is the question you ought to be asking. And most importantly, if you can function through trust, why would you need to go through all that? Function through trust so much that they don't even bill you with the typical stuff they bill other people because of the qualification standards. When you pay those yearly fees of license registration, that's just a form of taxation of its own. A form of taxation based on use. In order for you to use this machinery on our road, we have to tax you by giving you a receipt that you put on your vehicle every year to say you're good to go. But if you're functioning through a trust, none of that matters. Ask yourself these basic questions first. An individual operating or traveling in an automobile does not lose all reasonable expectation of privacy, meaning your right to privacy still exists. It's the stuff people want to hear, right? Cool. Well, there it is. Simply because the automobile and its use are subject to government regulation. This second part also tell you, even though someone says they want to regulate your vehicle, they're not saying they're regulating your right to move from one place to the other. Get that right and get that very clear. It's not your ability to move from point A to point B is what's being restricted. Now, when they put people under house arrest, that's what's occurring. But when you're in your automobile, vehicle, whatever terminology you want to use, your ability to move to and fro is not what they're contending. What they're contending is your right of use of that machine on something that they have built. See, here's a missing link that most people who go on about automobile, private right to travel, that they don't know. They will not tell you this because they don't know. And the ones that know will not tell you. Synonymous with how the guy who took over McDonald's business basically always have interest to the land before the franchisee, aka sharecroppers, aka shareholders, to McDonald's before they own a franchise. He owns the land to which the structure of McDonald's and where the business is going to be taking place. He owns that. In other words, the concept of first place ownership, first and then older, and the control by virtue of that comes into play. Whoever owns the land controls everything else that's performed and how the right of usufruct is enforced on that land. The same foundational principle is exactly what's going on with the land that people travel upon. That is the missing link in a lot of people's mind when it comes to right to travel, this and that, and the regulations thereof. That is what most people do not know. Most people who go on about right to travel, it's not an issue. Your right to travel and move about is not the issue. It's how the use of that land comes into play. That's the concept and principle as to why it was mentioned in the earlier res judicata we read when it spoke about public interest. That public interest is your right of use to that land that you're moving on and off. And they have predominant regulation as to how certain machinery is that's used on said land that they build and have interest ownership of, how it can be used. You now, your substantive right to be free from search and seizure, and your substantive right to pursuit of liberty and happiness, which ingress and regress is part of, that becomes part of what they have to balance, as mentioned in the earlier res judicata. That's the reason why they put those three attributes of public trust doctrine, aka public interest, and your substantive right with theirs. That is the thing that no one will ever tell you about right to travel and all that crap people go on about. People keep focusing on the wrong issue. Ignorance will screw your life up, when in truth the substance is far more straightforward and simpler than you think. Focus. That's the core of the issue. And they're saying despite that, your right to privacy and the reasonableness to presume or expect that you have that right is still not thwarted. It's still not removed or separated, even if there's a presumption that they have the right to regulate machineries on that which they created. Are you following? It goes on to say, people are not shorn of all, meaning to be shed of, to be removed, to be separated. People are not shorn of all Fourth Amendment. It says all because the Fourth Amendment or any given section can have several clauses to it, and each clause can be a specific right to their own. For instance, the Fourth Amendment speaks about the right to seizure, security of persons, papers, and effect. Those are different types of rights. So people are not shorn of all Fourth Amendment protections when they step from their homes onto the public sidewalk, nor are they shorn of those interests when they step from sidewalks into their automobiles. That's the good stuff. That's the positive news. That's the good news. But I'm not here to cater to people's perception or to modify information to make it sound good or interpret it to what people want to hear by limiting the truth. The truth does not take any side. Now, what you choose to do with it is up to you. But whatever you choose to do with it, Know the reality that you're stepping in, and most importantly, the importance of competence and how to change reality before you just go around expecting someone to submit to you because you think one way or because you read one isolated information and you run away with it. Know your rights, but know the underlying factor to why the opposing party can do what they do. And Art of War lets you know that information is how you win any war. Information is hidden from people. So people are working with very small information, isolated pockets of information, and they are losing each engagement every day, every month, every year. And that is system make more money. They'll even show you publications and memorandums through each city, through each county, that hey, arrest tickets have went up by 215%. That's good news. They show you their brochure of them smiling, getting awards. Why? Because you don't know what you are doing. But it doesn't have to be that way. Be competent. Know the totality. Don't see one isolated event and run away with it. See all sides and operate accordingly. Because ultimately, all these things actually favors you. But how can you enforce that which favors you functionally, actionably, if you don't see the totality of circumstance and you're just walking into one cobweb after the other, one cobweb after the other? That's the good news people like to hear. Supreme Court of the United States. Rodriguez versus United States. Certiorari to the United States Court of Appeals for the 8th Circuit. Case number 13-9972. Remember, there's a doctrine that states where there's some type of discernment to be made between federal decision and state. Federal will always supersede because the states came together as a form of treaty to create the United States. So the state themselves are part of the quote federal government. This is also the reason why most states don't own as much land within their states than federal governments do. In other words, the state of Texas don't own as much land within the state of Texas as much as the United States does. Interesting dynamics. But nonetheless, another case law, Supreme Court of the United States, case number 13-9972. So during a traffic stop, what is the limits and bounds of what these municipal employees can do? These people that are armed military men. What is the limits and the job description of what they are supposed to do? Most of these people that interface with quote cops don't know the limits and the bounds of their job description. What they can utter is you're supposed to follow the law, this and that. Okay, yes, they are. But what is the limits and bounds? You have to be specific because all laws are specific when it comes to traffic situations. What is the limits and bounds to which they are to function? This case law tells you that beyond determining whether to issue a traffic ticket, meaning whenever anyone steps into any vehicle, any automobile, any machinery, call it whatever makes you feel comfortable. Whenever you step into it and you go onto these roads, there are criteria to which these people can perform towards you. One of them is traffic violations. Did you move too fast during a speed limit? Did you put someone's life in danger? Did you not stop at the traffic sign? All those basic things are not crimes. So yes, we know none of those are crimes. Traffic-related situations have not been, they are not, and they cannot be crimes. They cannot be related to criminal activities. It's common sense. And guess what? These people don't presume it to be. Only you make that argument and get stuck on that contention. So listen carefully. Beyond determining whether to issue a traffic ticket, which are the stuff that are not criminal in nature, an officer's mission, we're not here to contend whether they hold office or not. There's many things to this. All these people that love reading dictionaries, law dictionaries, read the varying degrees of what this term officer means. We're not here to contend otherwise. An officer's mission includes, quote, ordinary inquiry, mission being their job description. An officer's mission, besides determining whether to issue traffic ticket, aka traffic infraction, their mission includes ordinary inquiries incident, meaning a consequence of, or something that came out of, to traffic stops. Now, their primary issue when it comes to traffic related matters are things that are not criminal in nature, such as the things we mentioned earlier. But other things can be done in the process of set, quote, traffic stops. So a traffic stop is not just determining, okay, did you run the red light? Okay, I'll issue a citation or a warning. There are other things that's, quote, classified as ordinary inquiries incident to the traffic stop. So what are these ordinary inquiries? It goes on to say, typically such inquiries involve checking the driver's license, determining whether there are outstanding warrants. Checking a driver's license includes determining the jurisdiction of the one controlling the tool that's moving about on a surface that's built for private interest, aka personal jurisdiction. Personal jurisdiction is determined whenever some form of tool that aligns with the commercial interest that they have is presented to them. That's one. And there are international laws that governs this, that removes you from that, which we've went over on Patreon. Two is determining whether there are outstanding warrants against the driver. Another way to gain personal jurisdiction is to see, are there any other commercial interests that you've yet to finish entertaining somewhere that other entities or similar entities can enforce, aka if the warrant is extraditable, or if you have a warrant within said county, or issued by whatever city, state, borough, town, village, whatever it is. In some cases, even if the warrant is active and it's not extraditable, then they can't do anything. So when people say, oh yeah, I have my injunction in, but I have warrant, and they said, oh sir, you have a warrant, blah, blah, blah. Oh yeah, the injunction worked. Okay, cool. But did you ask yourself if the warrant was extraditable, meaning another county or another state can force that injunction? If not, then according to how Fourth Amendment work, unless it's extraditable, even if they know that you have a warrant, they still can't arrest you for that. So know the intricacies before being delusional about what works and what doesn't work. Hey, look, I'm just being honest with you here. I'm not here to take sides of what you think works and what doesn't work. And the injunction is an equitable relief that does what it needs to do when appropriate. So the contention here is not that it works or not, but be realistic as to how it applies to warrants or not. The first responsibility outside of issuing traffic tickets that municipal armed employees can enforce is determining personal jurisdiction by looking at the tool that you're using to identify yourself while you're operating some machinery. Second is to determine whether there's a warrant that they can enforce. And three is inspecting the automobile's registration and proof of insurance. Is this thing under our jurisdiction? Which is the reason why you have to put it under an entity's name. That naturally is a body politic of its own. All these activities are a form of taxation. Taxation is not just someone dinging into your pocket saying, give me monies. Taxation is someone depriving you of a certain act. A lien on your credit report. A lien is whenever someone puts something that affects your credibility on your credit report. Someone has effectively put a lien on your commercial interest or your personal lifestyle based on what they say your credibility is by putting something in your credit report. There's an equivalence of a credit report when it comes to something called a rap sheet, when it comes to everyday life. You have to separate these jurisdictions through the tool that you use. And those tools that you use are either the machinery or the stuff that you use to identify yourself. These are the fine lines that sometimes some people have some idea about, but they don't stop and think about the fine-tuned details. A third res judicata, Pennsylvania versus Mims. Case number 76-18, 30. Question: do police officers violate the Fourth Amendment's prohibition against unlawful searches and seizures when during a routine traffic stop? Routine traffic stop being those foundational criteria that we just defined earlier based on the previous Ascertain versus United States. See how all each of these decisions lay on top of each other? They're not obligated to define to you what routine traffic stop is. You have to know what it is, and we just went over that. The foundational principle of interest and what needs to be balanced. Then we transitioned into what these cops are supposed to be doing and what the scope and confine of what they do is relating to you in any given activity. And then, believe it or not, we went over the solution for you. Up to you to think, listen, and take it and put it to use beyond speculation. And 3, we're now going over this scope that these people have and the underlying factors that ought to be put into consideration. When certain things are done, do police officers violate the Fourth Amendment's prohibition against unlawful search and seizures when during a routine traffic stop? Obtain evidence through a search conducted after asking the suspect to exit the vehicle without a justifiable reason to do so. In other words, a lot of people are familiar with this thing where they ask you a series of pitches that they've been conditioned to ask people. No matter how repetitive pitches are, they work. That's how sales are. You might have heard the same pitch 20 million times, but there's something about the mind and a certain pattern of repetitiveness and the comfort from that which is enforcing that question and pitch that allows it to work even if someone on the other end is familiar with it. Unless the other one on the other end who is familiar with those pitches know the perfect counter to it. And the only way you can know the perfect counter to the pitch is if you know the intent behind why it exists. If you don't know the intent behind why these pitches exist, in which case, in this situation, they'll ask you basic question, blah, 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 and then they tell you, step out of the vehicle, sir. That's a basic routine pitch that they go through. So the question now is your substantive right preserved there in the Fourth Amendment during a routine traffic stop, which we went over? In the process of balancing certain things, is that right violated when they ask you, or after they're asking you to exit a vehicle without justifiable reason to do so? That's the question that's entertained. Primarily, many things are entertained within this res judicata, but primarily, the main question is the moment they tell you to step out without having a justifiable reason, does it violate the Fourth Amendment in the process of a routine traffic stop? Remember, the presumption here is that whoever's been told to step out is a suspect. In order for you to be a suspect, there has to be a suspicion of what? There you go, a crime. This is where the concept of the existence of a crime first has to exist in order for an arrest process to occur, in order for the process of deeming you a criminal to be triggered. During a routine traffic stop, the underlying factor here is someone has already been suspected of a crime. And we know that part of what a routine traffic stop is if someone has an outstanding warrant that's enforceable, or if the personal jurisdiction based on the tool that they use to identify themselves puts them under the jurisdiction of whoever it is that's enforcing one thing or the other. The problem most people make is they make up some ID that mimics the state of so-and-so. That's unlawful. We went over that. Or some people making some private ID. Okay, cool, not a problem. But is it accordance to international law? That's the question you ought to ask yourself. So the presumption with this question is that someone has already been suspected of a crime. And the stop and frisk, aka Terry stop doctrine, basically states 3 things. There has to be a reasonable expectation that a crime was committed, is being committed, or is about to be committed in order for an investigation of a crime to be triggered in order to determine probable cause. Investigation of a crime exists for the purpose of having probable cause, because if there's no crime, then there's no probable cause. But they create a loophole to probable cause, which is a very low standard of evidence, by the way. They create a loophole for themselves, which is called Terry stops, stop and frisk, meaning we're going to give ourselves the opportunity to investigate the potentiality of a crime based on something that we see that has occurred, is occurring, is about to occur. So even with a loophole itself, there has to be something that they've seen that they have to reasonably articulate that has existed, is existing, or is about to exist, that is contended to be a crime. Hence, a suspect. You cannot be a suspect if there's no reasonable articulable expectation that a crime was committed, is being committed, or is about to be committed. Listen to that again until it makes sense. So the question once more is, when someone is already under the premise of being a suspect to a crime, and that crime was found in the process of a routine traffic stop, although a tool of a traffic stop is not to investigate a crime, but given the fact that they can check IDs, that IDs can then subsequently be used to find whether someone has a warrant, aka a past suspicion of a crime, or that they are related to some current or anticipated crime. That is a loophole within a routine traffic stop of asking for ID that they can use to casually blend into an investigatory stop. You have to know these loopholes. It's very important. So the question is, once someone has already been suspected of a crime, by way of asking for their ID, does that violate the Fourth Amendment? Again, the premise is someone has already been suspected. If someone is already suspected of a crime, and that crime was found during a routine traffic stop, even though traffic violations are no crimes, but if in the process of that, quote, routine traffic stop, which includes checking people's ID, if it is found that someone has a warrant or is currently engaging or has engaged in a crime, which traffic infractions are not, and they suspect them lawfully of a crime, does it violate the Fourth Amendment? You should know the answer to that. It is no. In a 63 per curiam decision, the court held that the search did not violate Mims' right under the Fourth Amendment. The court noted that the officers had already detained Mims in order to issue him a traffic summons, and felt that asking him to exit the vehicle was a minimal and reasonable intrusion of his freedom. Whether the search occurred inside or outside the car was irrelevant to the court. The officers had stopped Mims for a legitimate reason, and upon the legitimate reason was for a traffic stop, a routine traffic stop, and then upon observing the bulge in his jacket, any person of reasonable caution would have conducted the search, aka a Terry stop, which we'll go over the constituting factor of a Terry stop. In summary, the constituting factor of a Terry stop is it has to be for the purpose of revealing that someone is armed and dangerous, for the purpose of protecting society. It must be brief and very quick. And before said brief, quick search to find a weapon occurs, there has to already be an expectation that a crime existed, is currently existing, or is about to. So in this case, they're saying since a bulge was seen on his jacket, there's a chance that a crime could occur because he might be carrying unlawfully. Now, this might not apply to you because you might be lawfully carrying, even with the bulge on your jacket. But in this case, it was not. Justice Thurgood Marshall wrote a dissenting opinion arguing that such searches, in order to conform to the requirement of the Fourth Amendment, must relate to the reason for the stop. Because the officers had detained Mims for an expired license plate, meaning now there's a valid reason to stop based on the regularly conducted business activity of traffic stops. But later on, they found something else. And one of the acting judges says that in order for the search of the person to be validated, it has to relate to the reason for the stop itself. They're going to say because the officer had detained Mims for an expired license plate, searching him for a concealed weapon was not within the scope of the stop. Because the officer had detained Mims for an expired license plate, a traffic infraction which is not a crime, which does not warrant a search or a seizure, searching him for concealed weapons was not within the scope of the stop, traffic stop, and therefore made it a lawful search. That's what one of the acting judges said. Remember, 6 said nope, it didn't violate the Constitution. 3 said yes it did. And one of the ones that said it violated the Constitution said the reason why it violated the Constitution is because the search itself had nothing to do with the initial stop. It then goes on to say Justice John Paul Stevens, joined by Justice William Brennan and Thurgood Marshall, making 3 of them, filed a separate dissent arguing that majority opinion, aka 6 that says no, the search does not violate the Constitution, even though it's not related to the initial stop. They filed a separate dissent arguing that the majority opinion gave too much discretion to police officers, allowing them to search detainees whenever they could invent any basis for concern. This last part is the reason why we are going through this case law. We're not saying one thing is right or wrong. What we're saying is to bring your attention to the fact that certain loopholes exist that you are not aware of. And it's been spoken of. When was this res judicata? This was in 1977. Most people going on about their rights were not even born during this time. And if they were children during this time period. And this subject matter and this concept has already been entertained since 1977. We're not saying whether the search and seizures are right or wrong or whatever loophole they have. We're saying enlighten yourself and be aware of the varying degrees of what rights constitute and know what the red flags are. This is the red flag to Terry stop. Terry stop does not delineate that said stop has to be fixed to initial reason why you were initially stopped. Meaning Terry stop can be invoked in the middle of any other situation. This is the reason why people will call cops for domestic issues or seeing some dogs running around or that a child is choking, and then all of a sudden the cop will come, they will ignore the choking child and they will arrest you. Yep. Or you are running away from some people who want to steal your stuff and you call the cops, but the cops ignore all those group of people and they arrest and kick your ass. These are the loopholes that they use to say, despite the initial thing that existed, we will now retroactively create the issue ourselves because, well, Terry stop. So what is this Terry stop situation, which is the loophole to traffic stops or otherwise? In summary, remember, routine traffic stops involve asking for identification. And asking for that identification, if they found something else to say, let's see, we should search you because you have an outstanding warrant. The question you have to ask is that warrant enforceable in this state or not? But they'll generally just throw the blanket out. You have an outstanding warrant. So now let's search you. Or, well, you look to be acting nervous and suspicious, which we go over on Patreon page. The factors that can be used to either validate unreasonable use of force as a loophole or invalidate it. We went over that. There are decisive specific to that. But these are the loopholes you must know if you say you have a right, because this perspective of this loophole and this wide discretion will be the primary and sole factor as to how they're going to approach you, with very few exceptions of honorable ones. If you don't know these loopholes where they're going to basically limit as the scope of what they're supposed to do, and you don't know the totality involved in everything of what they're doing and what you say you have the right to do, you're setting yourself up. Because if you have a right, you have some form of power, and with power comes responsibility. Most people who say they want to be private or have rights to this, right to that, all they're speaking of is responsibility, but most people are not ready to take self-responsibility. That's the issue. And the self-responsibility begins with first being competent, knowing the totality of circumstance rather than isolated pockets of information. The same res judicata, Pennsylvania versus Mims, goes on to say, we hold only that once a motor vehicle has been lawfully detained for a traffic violation, the police officers may order the driver to get out of the vehicle without violating the Fourth Amendment prescription of unreasonable search and seizures. In other words, they're telling you if anything exists during any traffic routine checks, they can tell you to step out of the vehicle without it violating search and seizure. Albeit they can use that as a tool to kind of visually inspect and visually search. This thing called search involves visual inspection. When they're telling you, oh, we're just going to do an inspection with a canine or just our flashlight, that is search. That does constitute search. What about people who tint their windows? In statutized legislature, they say you can have tinted windows if it's this percentage. We'll go over that. Once again, we're not saying one thing is right or wrong. These are the loopholes that they have sitting for you. You who claims to have a certain right to do one thing or the other. If you don't see the totality of circumstance, you're stepping into a terrain to get your butt kicked. It's like going into a war zone against tanks and you are riding on horses. The ammunition from that tank, once it combusts and goes towards you, one, it's bigger than your torso. And the speed and at rate that is coming at you, it would shatter you and that horse. You have to know the playing field. If you didn't get the memo that this is a war of tanks or you need some type of airstrike to get things done, to counter it, and you're going there with horses to say, all right, let's go, you're setting yourself up. You have to know the terrain that you're battling in. Your will to go into battle and yell to say, yeah, let's go, that's not enough. Information is how you survive any type of engagement. The difference between someone who has and someone who does not, the difference between someone who's rich and someone who's poor is what they know. And being rich or poor, we're not speaking about material wealth. It could be also that way. And in fact, it is materially. But when it comes to other type of wealth, riches, most people think they got it figured out, but they don't. They are still walking in blindness. It's like walking in a dark room with a bunch of cobwebs. That's what people are doing with what they say their rights are. The next one, Supreme Court of the United States, Arizona versus Johnson. Certiorari to the Court of Appeals of Arizona. Case number 07-1122. It goes on to tell you, to justify a pat down is another word for a Terry stop. A Terry stop, aka a pat down, is another word for stop and frisk. Stop and frisk, aka a pat down, aka Terry stop, is another word for investigative stop. Know these varying degrees. To justify a pat down of the driver or passenger during a traffic stop, which is a follow-up. This is like a story that's occurring through these case laws. The year this took place is in 2009. So all these case laws build upon one another like a story. You'll read one page, you'll flip the next. The next story to that book might occur 10 years later, 50 years, 20, 30 years later. But if the story to that book is being written and you don't know about it, it would only affect you. Whereas the government is supposed to amend itself to you. Know the totality of what you say your rights are. To justify a pat down of the driver or a passenger during a traffic stop. However, just as in case of a pedestrian reasonably suspected of criminal activity, meaning the presumption here is traffic stops are not crime related. However, in order to justify a Terry stop, investigatory stops exist for the purpose of finding a crime in order to create probable cause. In order to justify that during a traffic stop, just as in the case of a pedestrian reasonably suspected of criminal activity, meaning there has to be a reasonable expectation of a crime, which will trigger need for a pat down, aka Terry stop, aka investigatory stop, aka stop and frisk. During a traffic stop, whoever it is that's engaged in the opposing end of that traffic stop, you have to be reasonably suspected of a criminal activity. How is the justification of what's reasonable to be a suspicion of a criminal activity? How is it determined? They say it is determined by the fact that the police must harbor reasonable suspicion that the person subject to frisk is armed and dangerous. Ding, ding, ding. In other words,
Nobody can search or seize you during a traffic stop if there's no reasonable expectation that you are armed and dangerous. I'll repeat that. Regardless of all the loopholes that they've created, in order for Terry stop to be justified, whether you are operating some type of machinery within a traffic stop or you're just the everyday man going by minding your business, the concept of a Terry stop, aka investigatory stop, aka stop and frisk, aka a pat down, the concept to trigger it has to be expectation that you are armed and dangerous. In the Pennsylvania versus Mims case, they saw a bulge in their pocket, which later they found some things. There are other case laws whereby same thing occurred, but they were not armed, and the cops were later sued, and whoever sued won. So there are varying degrees to these things, but you have to know the criteria. The one who won that circumstance knew this fact. Most people don't know this basic fact, so they get taken advantage of. Most of the things that occur with search and seizure and traffic stops are classified under the Terry doctrine, under the Terry condition, aka pat down, aka stop and frisk, aka investigatory stop. The need to investigate a crime has to solely exist when there's a reasonable expectation that someone is armed and dangerous. And then comes the concept of intent. How do you intend to use that firearm? Have you used it in the past for a crime? Are you currently engaged in a crime with it? Are you about to use it for a crime? These are the foundation many people lack. United States versus Johnson. Case number 20-1050. February 24th, 2001. This is September 2022 we're currently at when this video is made. Might not be uploaded maybe about a month until now, but this is still 2022. And this res judicata is as of last year. Listen to what they're saying. These are appellate decisions. United States of America plaintiff appealee versus J. Nicole Johnson, defendant appellant. Meaning Johnson is appealing against United States of America. They're bringing the power of the people of everyone within each state against this man or woman. And this man or woman is appealing against that. As mentioned in many other videos, when they say people of the state of so-and-so or the state of so-and-so versus you, what they're saying is they're bringing the power of the people, your power, against you. When they say United States of America, they're saying they're bringing the power of everyone from each state against you. In case that's not clear, most people aren't even aware of that rudiments. But nonetheless, this man or woman is now appealing against the presumption of the power against them, relating to the same subject matter we've been speaking about. And the specific part is this: an officer may stop a person based on a reasonable suspicion of criminal activity, but to frisk him for weapons. Meaning the suspicion of criminal activity is very, very, very specific for the search of weapon. An officer may stop a person based on a reasonable suspicion of criminal activity, but to frisk him for weapon. The officer must reasonably believe he is armed and dangerous. Terry versus Ohio. There's a video we did on this regarding Terry versus Ohio and reasonable article of suspicion in Fourth Amendment. Go watch that for the foundation of Terry versus Ohio. Indeed, we have recognized that the Supreme Court have never, this is as of 2021, the Supreme Court have never authorized a protective search. Meaning, we will search it because, well, we want to protect for our officers' safety. We want to protect ourselves. You will hear them every now and then throw that trash out, right? And they say that we have recognized that the Supreme Court have never, they even put in italics, to make it succinct enough within the rest of the word. The Supreme Court. We recognize that the Supreme Court have never authorized a protective search on anything less than reasonable suspicion that a suspect was armed and dangerous. Oh my goodness. In other words, Terry stop and the need to arbitrarily stop someone without probable cause is only specific to the need to find out whether someone has ammunition or firearm. Anything else that's found outside of Terry stop, which is limited to the discovery of firearm, is classified under the fruit of the poisonous tree, which a video of that was done, which is the fact that anything that's found that violates the need for probable cause is unlawful. Probable cause is not confined to just the search of firearm. Terry stop is. So now when someone invokes Terry stops without the existence of a probable cause, that means the limits and the confines of what they can search and find and use as evidence against you is firearm. So now during a regular routine traffic stop and they begin to search you, are they letting you know, or are they claiming that they suspect you of bear arms unlawfully? That is if you are doing it unlawfully. And that's a whole nother subject matter as to how you can bear arms unlawfully, because there are different categories of firearm. There's the purchase, there's the carry, there's the transport, and there's the use. Those are 4 separate categories when it comes to firearms that most people don't even know. But let's not deviate too far. When it comes to traffic stops, the only time they can invoke an investigatory stop is for the purpose of finding out whether you have a firearm. And the only way that they can say we want to find out you have a firearm is if they have a reason to believe you already have it on you unlawfully. We're not speaking about whether the possession or the carry of the use of it is lawful or not, but we're just saying they are suspicious of something, and the only thing that can cause them to say we're suspicious of a crime and so we have to search you is if you are armed and dangerous. That's it. Nothing more. Do you see the loopholes that they've created for themselves and what kills said loophole? We're not saying one thing is right or wrong. We're showing the problem and we're showing the solution based on their own words and self-confession. And this came out of a res judicata from last year. Law and its operation, called legal things, are invincible strings that attach to everyday reality that affects people. Whether you realize it or not becomes your problem, because that problem is fettered and attached to what you say your rights are. And the one willing to take advantage of you is not obligated to tell you, hey buddy, you have a problem there that you need to solve. Why would they? When they're benefiting from it, making millions from it, generating wealth that will last them and 20 generations to come. Why should they? After all, you say you have rights, so you should have the power and the knowledge and competency to know the dynamics and intricacies of everything involved. Should you not? An officer may stop a person based on reasonable suspicion of a criminal activity, but to frisk him for weapon, the officer must reasonably believe he is armed and dangerous. The only time an investigatory stop, aka Terry stop, aka pat down, aka stop and frisk, the only time it can be invoked is if there is in fact a reasonable suspicion that you are armed and dangerous. In other words, someone is afraid that you might kick their ass one day. To put it in a very nice term, they're afraid. But anyway, indeed, we have recognized that the Supreme Court has never authorized a protective search. Meaning, you municipal employees can be afraid of someone being able to just come at you and point a metal right in your head like you do with a lot of people, and have your life flash in front of you and you feel like a sissy. Someone can do that to you. So now we're not saying you can do Terry stop just to protect yourself. And we've never authorized or recognized that. Listen, indeed, we have recognized that the Supreme Court have never authorized a protective search, meaning to protect municipal employees who are armed against other everyday men who are armed. We have not said you can do a Terry stop for that purpose. On anything less than reasonable suspicion, meaning you have to first have a reasonable ground which can be attacked in and of itself. That a suspect was armed and dangerous. And not just that you're only armed, but you also have to be dangerous. So now you see the loophole that they've created for themselves in an attempt to circumvent probable cause retroactively. That itself has standards, which is the fact that they have to reasonably suspect, meaning they have to be able to show that this is the reason why I'm saying I'm invoking Terry stop. And once that is done, it has to be for the specific purpose of the fact that you're armed, and not merely armed, you also have to be dangerous. Then you have to be a threat to society. Hence, they always bring the power of the people against you. The people of the state of so-and-so against you. The state of so-and-so against you. United States of America against you. Once you really get it, it becomes very simple. And you will have no need to be upset. You will see the intricate details of every situation from beginning to the end. And guess what? Most municipal armed employees do not even know these details. Because their boss and the psychologist, yes, if you did not know it, municipalities spend millions of dollars on teaching their employees, no matter how stupid their employees are. They teach them how to psychologically manipulate people. They hire professional psychologists and professional hypnotists to train them in certain arts. So they're not training these people on the foundational principles of legality or law. They're training them how to manipulate people, because they know the people that are being manipulated don't know their rights. Did you know these intricate details before watching this video? Maybe you did. If you didn't, then take heed, learn, repeat, and watch it over and over again until you get it. Because these are the things that are the invisible cords, the invisible threads, the invisible webs that are affecting your life every day. It might not have done so in the past. It might affect someone you love. It might affect you during the most unexpected moment. But know this to prepare for the terrain that you're going to be in. Because this might be the difference between spending a night in jail or a weekend in jail, or losing a case and being turned into something that you're not. Because most of these cops have childhood issues that are not dealt with. So now they perpetuate the same like a bully does by looking for someone to make a victim out of. Now you're going to be emotionally and spiritually damaged, walking around life being angry at somebody because you chose not to be competent. It's your choice. Let competency of the world you're dealing with and the things that affect you on a substantive level, which is the stuff you can't quite see, and the things that affect you on a physical level that you do observe your five senses, let that precede anything you say or do when it comes to what you say is your right. Be the exception to the stupidity that exists en masse in this world. Don't run away from these things. It is your right to be well informed. And in fact, there are case laws that say someone only has a right when they're well informed. They use the term well-informed citizen. Whether or not you want to say the word citizen doesn't apply to you or not is a whole other thing, because you can still be a citizen, but it depends on the citizen of who, citizens of what. So the term citizen itself, just like the term person, is not the problem. It's the specificity of it. People get hung up in the wrong situation. They screw themselves over by virtue of that. Know what you say your rights are. Know the details. That way you can properly protect yourself, your loved ones, and hold tortfeasors liable. Don't just claim you have a right without knowing the intricacies. It goes on to say that the officer must be able to point to particular facts. The officer must be able to point to particular facts, meaning very, very specific facts. Not an opinion, not a personal feelings. The officer must be able to point to particular facts from which he reasonably inferred that the individual was armed and dangerous. This even came from the registered of the car from New York. New York is very notorious for stop and frisk. Additionally, they're clearly clear and convincing evidence is a standard of evidence also. There clearly must be some nexus, meaning a link between the criminal conduct of which the police suspect the defendant and the aim of the protective search. Additionally, there clearly must be a link between the criminal conduct which the police suspect, whatever they're saying they're suspecting you of, has to be linked to the intent and the aim of such search. This all means that, quote, a lawful stop does not necessarily carry with it the authority to conduct a pat-down search. Oh my goodness. Just because they lawfully stop you, aka seizure, does not mean they can lawfully search you. Just because you are lawfully seized, stopped, does not trigger a lawful search. Even though the constitutional secured rights on a state and federal level use the term search and seizure as though it goes hand in hand. Search is one thing, a seizure is another. Search has its criteria, a seizure has its criteria. The intricate details of a seizure is reasonable articulable suspicion, aka Terry stop, aka pat down, aka investigatory stop, aka stop and frisk, related to probable cause. And just because you were stopped does not trigger the lawfulness of any search that comes after that, because there are criteria, which is the fact that whoever stops you must be able to point to a particular fact that caused them to say that you are dangerous and armed. Thus, I'm going to search you without a warrant. The same foundational principle is being repeated in a different term over and over again so you actually get it. Because many people don't get this, but it's very simple. It is important to not confuse the scope of a frisk, the scope of a search, and the justifications and requirements for each. Look at that. A frisk and a search are different. A search requires a warrant, and a warrant is founded upon probable cause. A frisk is their loophole to say we can search you without a warrant, but it has to be very specific to a fact that can be pointed to say, I knew this guy, or I had a reason to believe this guy had a firearm and he was dangerous, so I frisked him. And that frisk in the other video regarding terror stop and Fourth Amendment and probable cause and reasonable articulable suspicion, we went over the requirements of terror stop. It has to be brief, it has to be quick, it has to be non-invasive, it has to be the outer layer of your clothing, and it has to be, of course, for the purpose of finding out firearm if you're dangerous and armed, which they didn't go over all those other details. They just summarized it and say you have to be armed and dangerous, and there has to be a reason for the man or woman who's saying that they're searching you or that they're frisking you, for them to say that you are armed and dangerous. You even hear it in description of police scanners. They tell you, oh, he's armed and dangerous, meaning, hey, here's a green light, you don't need a search, batter him up, frisk him as much as you want. He doesn't know it's right anyway. So we just use the code word armed and dangerous, because guess what? Armed and dangerous is a specific terminology used in Reg Judicata regarding stop and frisk. You have to know your rights. These people are not playing with you. These verbiage of these things do not favor them, but they will take and pick specific part because they know you don't know the totality of circumstance, let alone the subtle specificities of it as applicable to what they're picking and choosing to use against you. Know your rights. The government asserts that the officers could have reasonably inferred that Johnson was armed and dangerous, meaning this is how we define reasonableness of saying, okay, let's invoke a frisk. This is what's reasonable, because the frisk has a reason. Hence, a reasonable suspicion. There's a reason behind it. There has to first be a reason for us to say, okay, we're going to search and frisk you. And the reason behind it in this specific instance, which might be different from the infinite circumstance that might occur, in this instance, though, the reason is that the government asserted that the officer could have reasonably inferred that Johnson was armed and dangerous based on three facts. Quote, Johnson was a passenger in a stolen vehicle, meaning he was doing something he probably wasn't supposed to be doing. He was hanging around the wrong crowd, he was around the wrong people, and he was living life in a way that's arbitrary in and of himself. Therefore, arbitrary statutes, arbitrary enforcement of certain things can apply to you. Law of rhythm. Wherever your rhythm is what you're synchronized to. The car reeked of marijuana. This second part is arguable, and there are case law about that too. And Johnson appeared extremely nervous as he exited the car. We went over this as it pertains to the use of force on Patreon. In other words, what you do plays a huge role in what you say your rights are. Why are you nervous? If you know your rights, you have no need to be. Sure, your arms might get sweaty a little bit. Your armpit might get sweaty. You might stutter a little bit. That's normal. That's a normal reaction. But nonetheless, if you know your rights, you have no need to be. Because you'll be one with those rights that you say you have. Most people deep down know they're doing that which is wrong. And when that which is wrong that they do catches up to them, they now want to invoke some rights. Most people are hypocrites. But nonetheless, know your rights. Till next time, take care. And really, best of luck.
Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people, make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that are on YouTube are synonymous with things that are for the birds. One on the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the Express Trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More in discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how, and the importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference in the truth of legislative fact compared to adjudicative fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies. Tax evasion, we show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. Speak about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight, beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things of nature, how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.